Hi, I'm Anna Denton-Jones, and in today's session I want to talk about when an employee is accused of a criminal offence. Now, as an HR person, as a manager, we might not be that familiar with criminal law. We might feel we're out of our comfort zone, but hopefully by the end of this session, you will feel, actually, I do know what I'm doing. I do know how to handle this, and actually it's kind of usual rules apply, really. So first case to talk about is where there's some kind of connection with what the employee has done with work. So maybe they've had a fight with a fellow member of staff, or you've found that they're stealing or something like that, or you suspect that they are. You may have chosen to involve the police in a matter. Generally, there's no obligation on you to stall your processes. In fact, you might decide to deal with the internal issues before you then notify the police about something. One of the challenges might be if somebody has been informed that there may be criminal angle to what they're accused of. They may take advice from a criminal lawyer who will tell them not to say anything. So it can actually hamper your investigation. It can make it more difficult if you're up against that wall of silence. But the key thing, if you think about employment law, is that the person has the opportunity to tell you what their version of events is, to say what they want to say, to make representations in the disciplinary process. So as long as you're doing all of that, following your normal rules about a disciplinary, then you're going to be fine. Normal rules apply about reasonable belief in guilt. Civil rule, burden of proof. In our area, we're talking about, do I believe on balance that this thing has happened? Have I done a reasonable investigation? Have I got enough in front of me to make a decision? The fact that the police might be looking at a completely different burden of proof, it's a higher burden of proof in criminal law. They're looking for proof beyond all reasonable doubt that something happened. It's very different to what we're dealing with. So we don't need to get too tied up, if you like, with what's going on there with the police. What's more complicated, I think, is where we, perhaps second kind of case, find out that the employee's been arrested outside of work. Maybe they don't turn up at work. We've been tipped off by somebody. Sometimes we find out something's happened via the press in some shape or form. Maybe even the police come on site to question somebody. It's very easy, I think, to have a knee-jerk reaction when some of those things have happened, particularly if the kind of offence that somebody is accused of is something that's unpalatable. The key thing in those cases is we're always going to have to think about what is the nexus between the outside of work conduct and the work position. So is there a direct relationship? So if somebody works with children, obviously if they're accused of paedophilia and storing inappropriate images on their personal laptop outside of work, clearly there is a nexus. But sometimes it's about whether your name is being dragged into something, for example, in the press. So I always remember a football hooligan who had been arrested during some unsavoury behaviour, shall we say, in Europe, in one of the sort of Euro football matches years ago. Front page of the Mail, picture of this person in a hoodie, throwing something they shouldn't have been throwing, and it identified the person and the employer. So the employer of this person was the Royal Mail. So it sort of said Joe Bloggs, aged 42, works for Royal Mail, straight away that's bringing you into potential to say this is damaging to our reputation. So that might be an angle you need to go on. I think the hardest cases are the ones where there isn't that direct connection, but what somebody is accused of is something that maybe colleagues feel very strongly about and that is unpalatable, and is potentially going to cause friction. That doesn't necessarily give you the right to say, well, we can't employ this person anymore. I think we have to be a bit more nuanced than that. So that might be where you need to take some advice. Same principles are going to apply here. So an investigation, we may have to think about suspension. I'm always going to say, irrespective of what disciplinary issue we're talking about, that we should be risk assessing suspension these days. So it's not just a knee-jerk reaction, that we have set down in writing. It doesn't need to be particularly complicated. I've got a form that you just tick a few boxes on, sign it, date it, and then you've got a record of why in this particular case we've chosen to suspend this person. Police may want you to delay investigation whilst they're doing certain things. And I think that's where a conversation needs to be had, because whilst it can be, tempting to try and be cooperative with the police and to, follow what they say, because we don't want to do anything that is interfering with their investigation. So obviously, if they've taken work equipment away to go and analyse it, that's going to stall things. But we've got some wider issues to think about that the police aren't going to be bothered by. So things like how long is this going to take, and police investigations, and whether or not there's a prosecution. I'm currently waiting in a case to find out if the CPS are going to prosecute something. We're now in June. We've been waiting since November, December. So we're still none the wiser. So not quick. And of course, if you left somebody on suspension for all that time, we're going to get into trouble around things like breaching implied term of trust and confidence, constructive dismissal, and undermining the fairness of what we're doing as the employer. So it isn't necessarily the right thing to do to just sort of go along with what they say. I think we have to analyse whether what they're saying is reasonable, or you could find yourself in that how long is a piece of string scenario. But like we were saying before, usual principles are going to apply in terms of conducting your own investigation. We've got that different burden of proof. We've got to decide based on the evidence that we have whether we think it is reasonable or not to take specific action. Clearly, if somebody is accused of something that could have effects on them from a criminal law perspective, I'm not going to say we need to take it more seriously than we ever would in a normal disciplinary situation, because that's wrong. We should be being very careful to determine that we have got evidence to take action, and that is reasonable in all cases, irrespective of whether there's a criminal angle or not. But inevitably, if somebody's career could be affected, I'm thinking of teachers, care industry, all those sorts of things, where regulators are going to take into account also if you have been dismissed for particular reasons. We do need to be really, really sure that we are doing the right thing. Hopefully that's been useful. Hopefully you're not so frightened if you do end up in that situation. If you have got any questions, it's adenton@refreshinglawltd.co.uk. Thank you.